important stuff. And if you don't know it, it can really make or break your business. So please, this topic is going to cover things like employer penalties, regulatory updates, and enhancing participants' ability to navigate the benefit landscape. So please give your full attention, get your seat credit. I'd like to welcome our moderator, Jessica Watts from Frost Insurance, to come up to the stage, and also her panelists. So Jessica will be talking to Keyashia, Barkins, Grissom from Mercer Health and Benefits, Elizabeth Allen from Allen Benefits Law, and Ross Carmichael from Higginbotham Insurance Agency. Please give them a warm welcome.
Hi everyone. Sorry. They are letting us go a little early, and so I'm actually quite relieved because I was worried we were going to run long. I will try to give a signal when you can sign out of the CE, just in case anyone needs to do that. So I'm going to go ahead and start the timer for 15 minutes and get started now. All right, so thank you everyone for being here for this afternoon session. I'm very excited. I'm Jessica Watts, as you heard, and I am the compliance supervisor for employee benefits at Frost Insurance. And I'm going to let each of our panelists give a brief introduction of themselves, starting with Ross.
There we go. So I'm Ross Carmichael. I'm Managing Director of Compliance and DHE Services at Higginbotham Insurance Agency based out of Fort Worth. I've been there about 12 years. Prior to that, I actually went straight from law school, just like Keyashia, to the Department of Labor, where I worked for the DOL for almost 7 years doing compliance and enforcement. So I'm hitting up on 20 years of doing this. Good Lord.
Keyashia?
My name is Keyashia Barkins Grissom. I am a Senior Employee Benefits Compliance Specialist, Principal at Mercer Health and Benefits. Prior to joining Mercer, I spent just over 13 years, right around or so, at the U.S. Department of Labor. Spent some time with my good friend here, Jessica, over at Frost Insurance before I joined Mercer. And before I joined the Department of Labor, I was in law school. So I went straight from law school to enforcement to private sector. And that's just a little bit about me.
Hey, hi. I am Beth Allen. If you can't tell, we actually all came from the same place. So I worked with Ross and Keyashia in the Department of Labor. That was my first major job out of law school as well. Then I spent about a decade at a large insurance brokerage, NFP, and then I'm in my second year of my solo ERISA practice. So I went into actually being an ERISA attorney after doing, enforcement and then compliance work for 15 years. So happy to be here today.
All right, we're happy to have all three of you. So we're going to start with a pretty challenging topic, MHPAEA, so Mental Health Parity and Addiction Equity Act. That's a law that has been around since 2008, and it makes sure that health plans are treating mental health and substance use disorder benefits the same way that they treat medical and surgical benefits. So things like co-pays, deductibles, visit limits for all of those benefits for the mental health and substance use disorder benefits cannot be more restrictive than for those with the medical and surgical benefits. So more recently, the Consolidated Appropriations Act, the CAA, introduced some new requirements to strengthen MHPAEA compliance. That requires health plans, so our plan sponsors, to perform and document comparative analysis of the design and application of the non-quantitative treatment limitations to ensure that they're not more restrictive for the mental health and substance use disorder benefits than they are for the med-surg benefits. And so this is no longer optional, even though people, I think it was, but plans have to provide that to the DOL, the Department of Labor, upon request. So we have to make sure our employers are staying diligent and the health plans are staying diligent on top of this. Keyashia, Can you provide some background on how and why the CAA requirements were so instrumental in MHPAEA enforcement?
So, as a former investigator who actually used to investigate plan sponsors at the plan sponsor level to ensure compliance with the rules and regulations of ERISA, MHPAEA being a part of ERISA, the agency, there's plural here, but the one that I worked for, didn't have a whole lot of teeth, if you will, with respect to compliance, right? And so they were able to convince the original Trump administration to pass substantive law that would help enforce those rules. Prior to 2021, which is when the Consolidated Appropriations Act became effective and made the requirement to prepare an NQTL comparative analysis a requirement at the plan sponsor level, essentially all they had the ability to do was to enforce the financial requirements. And it was sort of a guessing game of, I think this is in compliance with NQTLs. And there wasn't a whole lot of ways for the department to ensure that they actually were in compliance. And by they, I mean TPAs, carriers, plan sponsors. Here's the thing, is the Department of Labor does not have jurisdiction at the carrier or TPA level. They have jurisdiction at the fiduciary plan sponsor level. So that's where Congress gave them the authority under the CAA to enforce those rules at the plan sponsor level. But we all know that the real problematic area is at the TPA carrier level. And so they are working at the plan sponsor level to get enterprise-wide compliance. What does that mean? We're going to go after your larger plan sponsors, some of your medium ones and some of your small ones, find the violations and make the TPA carrier fix it for everybody. So that's really what the goal is here.
Thank you. Ross, are you seeing mostly compliance or mostly non-compliance from those carriers and TPAs?
That's a loaded question.
And then also, what do you suggest that employers do if there is a non-compliance situation?
So I guess I would say it's pretty hit or miss. I think that the major issue we're running into is who is performing the analysis. Most of the major carriers will tell you, yes, we're in compliance, but we're only going to give you the information if you get the request from the DOL, and then we'll get you in touch with our legal team, and they'll provide you the comparative analysis. And obviously, we talk about are people in compliance. I mean, obviously, there's the report that gets generated every year that talks about whether or not there is compliance, and the most recent report found overwhelmingly that there was not compliance. The other issue we found is, again, that's on fully insured, or if you're ASO with one of the BUCAs, they'll just basically say, yes, we're in compliance, and if you get, but we're not going to give you certification of that unless you get investigated. With TPAs, especially if you've got carved-out pharmacy, carved-out stop-loss, etc., that's proven to be extremely difficult because it's a little bit of herding cats and who's on first. So there are third-party vendors that you can reach out to that will conduct the analysis for you. Even then, it's pretty hit or miss. I've seen some vendors that are charging well over 5 figures, and all they're using is the self-compliance tool and walking through that. We were at dinner last night and we were talking about this because that's what we do for fun. And I think Beth was saying she's seen a vendor that charged over $60,000 and basically still punted. So there is a little bit of inconsistency between vendors, carriers, etc. Overwhelmingly, we see, like, if you are looking at the true letter of the law, I would say most plans are not in compliance. That is just a fact. And it's again, when you mentioned, like, what about if you are out of compliance, if you're with a fully insured carrier, there's not a whole lot you can do other than push on them. What a lot of us are waiting on is there is a lawsuit that was filed against the administration to prevent some of the more recent regs that came out and would roll it back to the prior regs. That was supposed to have been, the answer was supposed to have been filed March 17th. They requested an extension, they requested 90 days. The plaintiffs said, we want no extension, and they cut the baby in half at 45 days. So I believe it's May 15th is the deadline for the response now, so it's going to be interesting to see what, if any, response they come back with, especially because when they even requested, especially with the new administration, and even when they requested the extension, they basically said, we don't even know what this is for the most part. We're trying to figure it out, and we're trying to see if we're even on board with it before we decide to defend it. So there is a little bit of a cautious wait and see, and in hopes that that lawsuit actually has teeth and they will roll back some of the more recent, more onerous regs.
Thank you. Beth, is there anything you want to add?
Okay, so sure, probably all of y'all are looking at us and still trying to figure out what MHPAEA is. And so what I'm gonna address is kind of what needs to be done. Like, what is the next step? And I think for the vast majority of your employer clients, they just need to ask for an NQTL comparative analysis. Ask the insurer, ask the TPA. In 2025, it's no longer acceptable for them to say, well, come back to us when the DOL asks. No, give it to us now, because even as a participant in this plan, I have the right to ask my employer for this. So insurer, TPA, give it to us, okay? I think where agencies come in handy is helping employers know when and where they need to go beyond that, right? So let's say that they get the comparative analysis. Again, they likely don't understand a word that's in there. Neither do you, frankly, right? That's what people like us up here kind of enjoy. But frankly, having it is the first step. After that, I will say that if your employers, especially the self-funded ones, have kind of a design where they have carved out mental health, where they have an especially, let's say, robust EAP, right, that offers quite a bit of mental health. If there's any kind of gatekeeping that the EAP does, in other words, you need to go to the EAP for therapy before you go to the health plan, then they need to take a step further and they need to be engaging a vendor potentially, right? But that's also where you all can kind of assist, because every vendor, frankly, that has jumped into this space is not actually qualified to do this, right? So ask a few questions. Ask them how many they've done. Ask them if they've been able to obtain the data necessary to kind of do some of the financial and operational testing. Because a lot of times they haven't necessarily, and it's not a good use of your client's money to basically go get this report where they're just basically maybe rehashing what the TPA or the insurer already said, okay? And so I would just say, get them to ask for the report, get it in their file, and then also just understand that, like, MHPAEA, we're not letting up on that. Like, there's bipartisan support from MHPAEA, right? Whether or not this final rule stays in place or it goes away, there's still the idea that we recognize the need for mental health, so that's not something that we're going to see going away. So just be diligent on easy things, like if the copay on mental health is higher than the copay on medical surgical, that's a red flag that we're still dealing with and shouldn't be. So everybody kind of needs to be diligent.
All right, so we're going to shift our focus now to another crucial area, reporting and disclosure requirements. So that falls under 5500s, plan documents, summary plan descriptions, and all those documents help to provide vital and clear information to plan participants. Keyashia, when you hear the term wrap plan document as a former investigator, what comes to mind?
A wrap plan document is a figment of the industry's mind. It is not what is required under the rules and regulations of ERISA. A plan document is what's required, and a summary plan description is what is required. Now, if you are filing 5500 for multiple benefits that meet the 5500 filing requirement, it is easier, it is cheaper, it is less problematic to wrap all those things up into one benefit plan document and file it that way, okay? But the wrap document is not a thing, at least not in my opinion. And when I say that, I mean when you ask clients in this space, do you have a plan document, a wrap plan document, they conflate a lot of things and they don't actually know what it is that they're supposed to have. They will hand you a bunch of benefit guides with no ERISA language wrapping them all together. That you've been filing 5500 like you have something, right? You're not necessarily in compliance with respect to your reporting requirements if you only have 5500 but multiple benefits that meet that 5500 filing requirement, okay? So when we're using this language, we need to make sure that we're making it clear to our clients and our plan sponsors what's actually required. There has to be participant-facing information that is written in plain language that they can understand. I'm from Texas, okay? When I was an investigator, how I used to explain it is, you have the Bible, that's your wrap plan document. It gives you all the legalese that you need with respect to the entire plan. And then you have your daily bread, that is your summary plan description. It breaks it down into bite-sized pieces so that regular people can understand it. If you don't have those items, you're probably not in compliance with some of your document disclosure requirements, right? If all you have is a benefits guide, and that's all you've been giving out, your OEE packet, you're probably missing some information somewhere. It's not that that's not everything, it's not you can't give that information, but it's not the only thing that you need to be giving out. So just make sure that when you're using this language that you're encompassing all the actual required information.
Amen. You had an amen, don't you? All right, so Beth, since your background actually encompasses both retirement and health and welfare enforcement, you have seen some progress on the retirement plan side, and now it's kind of going over to the health plan side. So what do you want people in the audience to know about what health and welfare plans need to be doing now? And I don't know if you want to lean on the retirement plan space at all as an example.
So interestingly, my esteemed colleagues here, we all started out with doing retirement and health. They just ditched retirement when they went into private practice. I still love retirement and health. And the reason I'm talking about retirement right now is because on the retirement side, the industry has been gracious in that they give you all of the plan documents, right? So on your retirement side, especially the IRS has greenlit what's called a prototype plan document, which means that your record keeper will give the employer the plan document. They will give them the SPD, and the employer is not left having to create one or have one created for them. That dynamic did not carry over to the health side, in large part because of the fact that the DOL barely enforced health for several years, right? When ERISA started in 1974, health was subject to it then. They didn't start actually full out enforcing it until we were there, right? Like in the 2000s. And so basically kind of that lag in enforcement of health plans meant that a lot of health plan sponsors didn't actually know what's required from the standpoint. But ERISA has always required an SPD of health plans. We just had nothing but insured plans that people were like, hey, here's the insurance certificate, right? And so keep in mind that on the retirement side, that's a much easier ask than it is on the health side. If the employer thinks, oh, I have an SPD from my carrier, they don't. And the carriers didn't help us out because some of them will actually say summary plan description, and it doesn't actually meet all of ERISA's content requirements, okay? And so I usually just explain it and say, look, if you have, let's say, an insurance certificate, if you are a self-funded plan, and you have something from the TPA, ASO, something has to come with that that's gonna make it a full SPD. If no one created that for you, you don't have one, okay? And so I think that's kind of an interesting dynamic of just how the two different types of benefits actually converged in how we document and disclose things.
Absolutely. Ross, is there anything else you want to talk about?
I think I'd just like to mention that when Keyashia was talking about wrap documents and wrapping all the lines together, I think one thing that gets overlooked a lot is a lot of people think worksite or voluntary products because they hear the word voluntary. For some reason, they're not ERISA covered plans. They think that they're completely voluntary, you don't have to file 5500s. You know, if it's like telemedicine or something like that, they don't need to be included, or HRAs don't need to be included in your COBRA offering. I will say there are very, very few worksite or ancillary or voluntary products that are not subject to ERISA. Even if they are 100% voluntary, and that is, I know it sounds weird, but under Section 125 rules, employee contributions to a voluntary plan are considered a form of employer contribution. So if you go through the flow chart of the voluntary plan safe harbor, almost every single plan that's run through a cafeteria plan that you wrap into your benefit guide. So I don't care if it's telehealth, LTD, STD, etc. Almost all of those plans are going to be subject to ERISA, and so you need to have plan docs and SPDs for them. You're not going to get those from the carrier, and that's where we get back to the wrap plan of if you're going to need all that ERISA language for each of those lines of coverage, and there's almost no way you're going to get that from a carrier.
All right, thank you. So before we dive into our next topic, we're going to talk about a quick update on the EBSA, which is the Employee Benefit Security Administration. As of now, we are cautiously waiting for Daniel Aronowitz, to be confirmed as the proposed nominee for the head of the EBSA, but currently there is no one at that agency running it. So that's the agency that all three of them worked for. It's responsible for protecting the rights of participants in employer-sponsored benefit plans. They oversee about 154 million participants in 722,000 retirement plans and 2.5 million health plans. And so we're going to talk through some of the investigations, how they're conducted, how employers can prepare. So Keyashia, I'm going to start with you. I hear a lot of talk about DOL audits. Would you like to address that term?
There's no such thing as a DOL audit. There's a DOL investigation. And I want to stress investigation because when your clients get the letter, it isn't going to say audit. It's going to say investigation, and they aren't going to freak out. That agency has criminal and civil investigation abilities. So if they're under investigation for a criminal issue, they can be under investigation for a criminal issue just as easily as they can be under investigation for a civil issue. Y'all use audit because IRS audits. DOL does not, they investigate, right? And so that's always been sort of a pet peeve of mine. It's like nails on a chalkboard, because when I would call and say, hey, I'm setting up a time to come out and investigate your plan, the folks would freak out, right? They might have thought I was coming out to just audit. And, you know, there is some audit activity that happens with respect to an investigation, but it is not an audit, it is an investigation. Investigators look at everything, right? They look at your operations, they look at your reporting, they look at your disclosure, they look at everything. That's not an audit. An audit spot checks, okay? Just a little pet peeve, we'll put that out there. No such thing as a DOL audit. That's the issue.
All right, Beth, so what should an employer do if they get a letter saying they are being investigated by the DOL?
So I will say most of you in this room, if not all, are covered by the Dallas regional office, right? So you may get a call and or a letter from that office, or one of your clients would, saying that they are going to potentially start an investigation. What you don't do is not respond, right? And employers, one tip I give often is that when it comes time to identify who to contact at a company, the DOL, generally, you're going to look at the 5500 and see who signed it. And some of your companies are putting a CEO, CFO there who don't answer their own phone. Right. If a DOL investigator spends weeks trying to locate you, they're much less moved to cooperate once they get you, right? So like, respond, please, okay? But also, I think the next thing to do really has to do with a lot of you all. You know, your clients should know that if they get one of those letters, if they get a call, that the first thing they do is they call you. They call you, right? Potentially, depending on what's going on, they call a me, right? So an ERISA attorney. Because if they are already, let's say, on notice that there's something an issue with their plan, they want to kind of get a lawyer involved as soon as possible if it is going to go that route. I think the vast majority of health and welfare audits investigations are not going to involve, let's say, criminal aspects, unless your clients are stealing, right? They're not paying for their insurance. But, you know, getting an attorney involved before things kind of go downhill is the best case scenario, right? I have a few clients who have come to me after the DOL already cites them for violations, and the letters, frankly, are not even as hard as what we used to do. Like, I've had letters where I open it up and it's like, the client said, what in the interview with the DOL? Like, why? Nobody coached you through what to tell the DOL and not to tell them, like, all the crazy things that you had no business saying. And so, like, if you call the attorney on the front end, they can help you with a lot of that, versus if you just wait until you've gone through a decent amount of the process, that puts them at a disadvantage. So I would definitely say, you know, have your clients lean on their service providers to help them get the documents, respond, be kind. If the investigator has to come to your business, don't put them in a closet. I had that experience. And so just kind of remember that DOL investigators are people too and trying to do their job.
All right. Ross, do you think that the current administration is going to change this practice, whether by increasing them, decreasing them? Go more in-person, desk investigations? What do you think?
The current administration, what day is it? Because that will change the answer.
Tuesday.
Yeah. So there's a couple different things going on there. One is, as Beth mentioned, most everybody in here being under the purview of the Dallas Regional Office. So Dallas Regional Office covers a 5-state region: Texas, New Mexico, Arkansas, Louisiana, and Oklahoma. When we were there 10 plus years ago, there were approximately 60 investigators on staff to handle that 5-state region. I think there's fewer than 20 currently. You throw in that obviously this administration is not real big on work from home. And that I think all of us would agree we were more productive when we could do desk audits or we could work from home, because we could request documents, we could do phone interviews, we could do Zoom interviews. The bandwidth it takes back when we were there to travel, go on site, look through documents, conduct a fiduciary interview, et cetera, come back, write your report, et cetera. That is, I guess I would say that process was improved, and that's going to take a step backwards. The same thing, you talk about, just in the regulatory landscape period, post Chevron decision with SCOTUS, there's no telling how many employers are now going to start trying to fight some of these things and say, we don't give deference to the Department of Labor on some of these things, we don't agree with them. How many ERISA attorneys will help them defend that on some of these things? And so I think it is a kind of a brave new world in the regulatory landscape with how people that are found to be in violation or believed to be investigated are going to, what that outcome is going to look like. I think, the other thing that people need to also be concerned of is going back to what Beth said about retirement plans. With limited bandwidth, the DOL, their primary focus has and probably will continue to be pension plans, especially if we get into any sort of recession. That's where you find, people, do I make payroll or do I take employee contributions and put them into the 401k? And instead of freezing the plan, which they don't know they can do, they just don't deposit employee contributions. And
they steal, is what you meant. They steal.
And so then, you look up and you have people that are looking at their 401k and say, I haven't, it's been coming out of my paycheck, but hasn't gone into my account in 6 months. Those are the cases that are always going to take priority over health plan cases. So
it's usually going to be around Christmas time. They're going to try to take out a 401k loan and notice that they don't have any money in there.
So if I'm hearing you correctly, there were about 60 investigators when you guys were there for your 5-state region. Now there's under 20. So if there's a limited number, the natural question is, why does an employer care about trying to be in compliance? And this is just an open question for whoever wants it.
So let me say that we talked about investigators, and there's another side of the house of the DOL called benefits advisors, and they take complaints from anybody in the country who wants to call and complain about a plan. If there's a call in, they're going to address that, right? And so those employers who might skate by and not necessarily get an investigation or become the target of investigation, if any of your participants are so much as unhappy, they can call, and then somebody has to work that issue, right? So that's always going to be a risk, in my opinion.
And on the health plan side, what that looks like, because we just talked about on the retirement side, it's at Christmas time I'm going to take out a 401k loan, and my money is short. On the health plan side, I went to get a prescription from the pharmacy, and the pharmacist said I had to pay full price. That is absolutely when you're going to find out that the contributions that were supposed to be forwarded onto the carrier or paid through the TPA to pay the claims haven't been paid. Claims haven't been paid, premiums haven't been paid. The pharmacist is immediately going to say you don't have insurance, here's your actual cost of your medication. They will pick up the phone and call the Dallas Regional Office and say, I can't get my medication because it's too expensive. What's happening? That triggers, it used to be called REACT. I think it might actually still be. It triggers a response system at the Dallas Regional Office to treat this like it's an immediate need to go in. And they go in, those investigators go in with the thought process that the plan sponsor is embezzling that money. So it starts off with criminal stuff in mind and not necessarily civil. So tell your plan sponsors that might get into some financial distress in the next, because recession comes soon, maybe. If they get into financial distress, stop the contributions. You can stop them. Stop them. Explain to your plan participants that you're in some financial straits, you're trying to work it out, you want to get a loan from the bank, whatever it is, stop the contributions on both the retirement side and the health plan side. They'll get there faster on the retirement side because it's, retirement, but on the health plan side, the hurt is longer, right? So stop the contributions, the first step, and then pick up the phone and call your broker or your attorney and figure some stuff out.
And I would say too that what Keyashia was talking about, the benefit advisors, they've gotten a little bolder over the past couple of years over what they think they have jurisdiction over. And just from an example, we had a client that had an employee call in, enroll over the phone, got confirmation through the Ben admin system after the employee was enrolled over the phone, enrolled an employee child. 6 months later, called back the employer and said, I never agreed to enroll in this, I want all my money back. And when the employer said no, you called and enrolled over the phone, we have the record of it, the employee called the DOL, and the benefit advisor called the client, so a client never wants a phone call from somebody at the DOL, and said you have to give this person their money back because telephonic enrollments are not valid. Which, A, they don't have jurisdiction over that. That's an IRS thing, because it's a Section 125 issue. But B, was insistent that this employer refund this person their money just based upon the person's word. So, we had to pull the recording or the person, again, but those are the hoops you have to jump through when you talk about why stay compliant, because those things are still going to happen. And so, just like with everything else in this world, just document everything.
As a mama of boys, I would also ideally say that they should care about compliance because it's the right thing to do. I'm serious.
Well, yeah.
Can you take your shopping cart back?
I do, every time.
All right. Okay, so let's move on to, we kind of touched on plan assets a little bit already, but we're going to dig into that a little bit more and fiduciary requirements. All right, so for so long, health plans, and I think all of us too as agents, and sometimes plan sponsors tend to think of that term fiduciaries as being specific to the retirement plan space, but as you mentioned, recent lawsuits are challenging that mindset. So as fiduciaries, plan sponsors, employers have a duty to act in the best interest of the plan participants and beneficiaries. This means they have to manage their plan assets prudently, follow the terms of the plan document, provide the 408B2 fee disclosures, which ensure transparency about the fees and the services provided by their covered service providers. Ross, what are some of the lawsuits that you're following on this topic, and what do you think the implications might be for some of us in the room?
Yeah, so probably everybody here has seen there have been a multitude of lawsuits filed, class action suits against large self-funded employers for violation of fiduciary duties and mishandling of plan assets. The first was Johnson & Johnson, which got dismissed, but then actually for lack of standing, but actually just got refiled with new plaintiffs. There was one against Wells Fargo that got dismissed. There's one that just got filed in March against JP Morgan. And they all kind of share the same tone or same theme, which they're all around pharmacy, they're all around PBM contracts and how the participants in the plan believe that the employer did not negotiate the best pharmacy contracts. And essentially they're saying, the participants are saying, I could go down to the pharmacy and give them my GoodRx card and ask for the cash price, and it would be less than I was paying under the terms of the plan because of the PBM contract. And those are kind of the gist of those lawsuits. I will say there is a bit of a distinguishment, and that's why when I said those names, those are massive companies. We can do a whole presentation on what our plan assets and trusts and those kind of things. Those are massive self-funded clients that are paying claims out of a trust. Trusts automatically, for the most part, are going to implicate plan assets. The bulk of clients that a lot of us have are either going to be fully insured or they're going to be self-funded, but they're going to be small enough that they don't have a trust set up. They're paying claims out of the general assets. That kind of gets around the trust requirements. So I do want to distinguish these lawsuits between, if you're, I think all of us have had a client sees one of these lawsuits and emails us and goes, oh my gosh, are we going to get sued too? And I'm like, you have 75 employees and you're fully insured with UHC. Like, you're not getting sued because of mishandling of the PBM contract. You can't even negotiate your PBM contract. Again, I do want to distinguish those, but obviously things snowball. I have seen there are TPAs out there that are selling self-funded or level-funded products to employers down as small as 25 or 50 employees that make them sign a trust agreement. And the employer has no idea until maybe they get an audit, or they're going through their 401k audit, 401k audit with their CPA, and they go, oh, well, you've got a trust on the welfare side, that's a funded plan, you need to have that audited as well, and they're going, I have no idea what you're talking about. So those are some of the things. Speaking on disclosures, there's a whistleblower lawsuit that a former broker filed against a large agency that said that they failed to disclose millions of dollars of PBM fees that they received in overrides to their clients on the 408B2 disclosures. So there's a whole bunch going on in this space right now. A lot of the SCOTUS is going back and forth over who has the ability to sue under these cases, who's actually been harmed, etc. So again, not to get into the weeds, but there's a lot of movement in this space. It's just something you need to be aware of and be able to speak to at a high level. Again, when you get that 75 life group that says, are we going to get sued because of something you gave? So,
Beth, what are 408B2 disclosures and why are they important?
Okay, so this is also like a history lesson in retirement and health. So we had 408B2 disclosures for retirement in 2012. And what was going on then was that the DOL was wising up to the fact that on the retirement side, there were all sorts of fees that were being paid on people's retirement accounts that the employer couldn't articulate, right? Like, I had a lot of retirement plan sponsors where I would say, hey, what's the fee? And they'd be like, my plan is free. Your plan is not free, okay? And so the DOL, as in Congress, frankly, came up with the idea of saying, okay, we have to do what's called a 408B2 disclosure, which means the retirement plan advisors, you have to tell your clients how much you are getting paid, right? And from what sources and what that looks like. Interestingly, at the time, I was actually on the DOL task force where we collected all of those to find out if they were deficient. And the first round were absolutely deficient, right? So then we put out some guidance. Fast forward to the CAA, we put this requirement in place for health plans, which is like, why did y'all just do it in 2012 when you did it for retirement? But the DOL was always a little bit behind the rest of the industry. And so they started to realize that on the health side, there's actually a whole lot more ways that folks are being paid than even on the retirement side. And so the requirement was to provide a 408B2 disclosure to your clients, basically before they make the decision of whether or not they want to go with you. You have to tell them how you're going to get paid and from whom. So that is direct compensation from them or the plan. That is indirect compensation from other people like providers and vendors and anybody who's going to provide you, some kind of kickback offset thing, right? And so that requirement has been around for years at this point. A lot of agencies still struggle with making sure they have one. And so I would just say that, like, your agency needs to be doing that. There were a bunch of templates that the industry put out. Some of them were like a page, some of them that some of us worked on were much longer. You don't want to fall in the shortest 408B2 disclosure camp, right? Even if you don't necessarily have to fall into the latter or the longest, but you want to have something, okay? And I believe we've had a couple of industry groups who have pressed the DOL and kind of asked Congress for why the DOL has not actually started to enforce the 408B2 requirement on health and welfare plans. So I think that's going to come soon as well, especially as we keep kind of trudging towards transparency and the idea that health costs so much because of some of these hidden fees.
All right, Keyashia, you kind of touched on this a minute ago, but can you speak to some of the plan asset issues that can come up, like funding accounts, paying invoices?
Right, so plan assets are tricky right? But they're fairly simple to understand. If it is an employee money, it's not employer money, it's a plan asset, okay? Does not belong to the employer. In those situations where they might be trying to decide whether or not to pay payroll, that was a great example because that's usually the decision-making process. I have this pool of money here and I need to make payroll. Do I forward the money to the carrier to pay the premiums, or do I pay payroll out of this? That money is the employee's money, and it was always the employee's money. They authorized you on their behalf to withhold it and forward it somewhere else. So if they were not participating in that retirement plan or that health plan, you would have to pay them that money. And when I explain it to plan sponsors, typically that's when the light bulb goes off that they've been stealing from their employees. Okay? It's not intentional usually, right? HSA monies are also considered planned assets. Now, DOL doesn't have direct jurisdiction over HSAs because it's an IRS thing. But you know when they come to knock it? When the money doesn't get where it's supposed to be because it's a planned asset, right? Those other type of account plans where you don't have a trust set up, you know what Ross was talking about, most plans that we work with don't have a trust. But if you're messing with plan participant money, if you don't send it exactly where it's supposed to go, when it's supposed to go there, there's supposed to be an account set aside just for it and sit there. It's not supposed to commingle with your plan sponsor monies, right? That is a prohibited transaction, and that's a no-no, right? That will get the Department of Labor come knocking real quick. So what we're trying to make sure you understand is that you get across to your clients that this money is not just an extra pool of money that they can just do whatever they need to do with because they're making business decisions. These are planned assets, and they need to be treated as such.
All right, we're going to move on to the topic of the employer mandate. So Ross, this question is for you. For many years, the IRS has been sending these lovely 226J letters that are assessing penalties under the employer shared responsibility rules. Are you seeing any additional enforcement action being taken by the IRS?
I guess I wouldn't say additional enforcement action. The information that they've been asking for on the responses and the rapidness with which they start sending follow-up letters has increased. So, for example, you know, those of us, if you've ever helped a client or assisted with a vendor that responded to a 226J letter, you could basically say, hey, we made a mistake on our filing, here's what we should have done, here's our SBC, here's our benefit guide, here's proof that we actually offer coverage, and we'll make the corrections on 14765 and send it back in. I've seen the IRS now start to say, like, okay, well, the mistake you said you made was you said this coverage was, you forgot to put an affordability safe harbor in. The employer could just go, oh, here, we use this affordability safe harbor, trust us. Now I've seen the IRS start to say, okay, send us the payroll records to prove that the W-2 safe harbor actually was affordable for this individual. Or prove to us, oh, sorry, that person wasn't a full-time employee that month. Okay, send us the payroll records to show that that person didn't work 130 hours that month. We've started to see that. Also, we've started to see, like I said, the quickness with which they're starting to follow up. We had a client we picked up recently, broke a record on. They obviously, remember, a lot of times these 226J letters, they come out 2-3 years in arrears. So, just now we're dealing with penalty notices from either 21 or 22. We picked up this client about 6 months ago. They have moved offices since. And so, since they first did their ACA filing, so they sent the first 226J letter to this company, their old address. It never got there because they've moved and it's been so long that they didn't leave a forwarding address. Finally, the new tenants sent the letter over. It was a couple months delayed. By the time the client got it, they had already received the follow-up letter, and now it went from basically by the time they got the follow-up letter it was around Christmas, and they were like, oh, we'll get to that after Christmas and the holidays. So they avoided letting us know, they avoided responding. By the time, literally, they sent us the letter and said, can you help us respond to this? The next day, it had moved to the notice that is intent to seize assets. So, and again, as a broker, we can't assist at that point. We have to go to outside counsel to assist them because that's actually a tax matter now. But so we've seen, like I said, a twofold process. One is a process increase. One is asking for more documentation and not just necessarily believing the employer. And two, how quickly they're going from notice phase to actual penalty phase. And I would also say, going back to that question asked earlier, how that works with the new administration and them laying people off, I don't know how that's going to affect some of these responses. That's just what we've seen in the last 2 or 3 months.
Well, Beth, what do you think?
Yeah, I think kind of as Russ was saying, I mean, a lot of these clients really do need to get a lawyer kind of to help them with this as soon as possible. The IRS is getting a little bit smarter on this, frankly. And it's not even just kind of the employer mandate side, but even reporting. You know, I've had clients now who it's like IRS realizes, hey, you give us 200 W-2s a year, but we don't have a 1095C from you, right? Which should trigger at 50 full-time people, right? Now, theoretically, that client could have, 30 full-time employees and hundreds of part-time or seasonal employees, right? But the assumption is that they did that calculation correctly, and the IRS is still gonna wanna know why you didn't file a 1095C, right? So they're starting to put some of those things together that they didn't do for several years. But yeah, I totally agree with Ross. I mean, that 226J letter that you're getting that from the 4980H kind of division of the IRS. They are very specific to this matter. They know the employer mandate rules. If you do not pay them, right, you let several notices from them go by and you don't pay, if you go to the next entity that is now just trying to collect the tax, they don't know anything about 4980H. And at that point, trying to negotiate with them just becomes more difficult, right? And so we definitely want your clients looking out for these letters, making sure that any letter you get from the IRS needs to be opened. Those are things that you would think are not an issue, but they are sometimes. And so as quickly as we can get this taken care of, that's kind of what they're gonna wanna do.
All right, so another hot topic that we're going to talk about has to do with innovative product and carve-out designs. So those can be new solutions for managing benefits. Keyashia, can you talk about some disease-specific fertility behavioral carve-outs that you are seeing and how they affect compliance?
So there's always a market for innovative and innovation, right? Innovative products. You get your disease-specific MSK, musculoskeletal, it's hard to say, type vendors, the Hinges and those of the world. You get your fertility benefits like carrots and the kind bodies of the world, and then you get your mental health vendors who, depending upon the type of relationship they forge with the client, they may be just an EAP, right? You're just going to them to just have the EAP services, all the way to fully carving out your mental health benefits under this program so that you can save costs, right? Everybody's looking to save costs. What these vendors often fail to do, right, is communicate how those benefits still need to be in compliance with the rules and regulations under ERISA. Like, just because you carve it out doesn't mean you don't have to comply. And you might think you're saving money by carving it out, but it still is tied to the medical plan because it's still a medical benefit, and it still has to comply with all of the same regulatory requirements that your overall group health plan would have to comply with. So is it really saving you money if you're carving it out? Now, there might be folks in here who potentially are doing those types of benefits, and I'm not trying to say that there isn't an avenue to save costs by going that route, but you need to be having those conversations with your employee benefit compliance specialists, whether they're counsel on the outside, your folks who work within your broker who do that area, to have those types of conversations. And you need to go back to your vendors and have those conversations with them, right? Because they're not always as concerned about whether or not the plan is going to be in compliance. But those IRS folks and those DOL folks definitely are. Okay.
All right, so Ross, can you talk about other cost-saving mechanisms that may test the boundaries of compliance?
There's probably not an agent in here who hasn't had a client email them and say, hey, I just heard about this Section 125 wellness program that if we put this plan in, we can save all this money on FICA and FUTA. And they're coming from business consultants or direct marketing or things like that. I will just say the IRS and HHS and CMS and DOL have not taken kindly to those types of programs as essentially, for lack of a better term, tax avoidance schemes. I know Beth and I are on the compliance committee, the compliance board committee for NABIT National, and I think I did a whole presentation on the risks of selling non-insurance products for brokers late last year. So feel free to check that out. Also, we've seen, as Keyashia was talking about carve-outs, I mean, there are vendors that will say we literally will carve out dialysis in the middle of a plan year while somebody is on dialysis. And we'll modify your SPD, or we'll do things like there are certain vendors that will say, give us a list of all your high-cost claimants, and we'll approach them and tell them about how they'd be better off if they get individual coverage, and we'll help pay for that individual coverage. And then we'll just magically invoice you for an amount that's equal to that individual coverage that we're paying for. So again, there's a lot of, obviously healthcare is expensive right now. Employers are looking for cost savings, but anytime somebody's leading with how much money an employer can save on taxes through a wellness program, that's usually going to be a red flag. If somebody leads with, hey, this is a foolproof way to get all your high-cost claimants off the plan, all your Medicare participants off the plan, you always want to go through those types of programs with a fine-tooth comb, because at the end of the day, the employer is going to be on the hook for any violations related to those types of programs, but then they're going to turn to look at you to say, why did you bring this to me? Or how come you didn't tell me I shouldn't do this?
That's great. So we are at 50 minutes, so you're welcome to scan out for your QR code. We do have one more topic area, and we had time for questions too. So I'll just have you kind of start thinking if you have any questions to ask for the panel, and then I'll ask the last question while you're thinking through that. As we wrap up today's panel, we wanted to quickly address the current regulatory developments that could impact employer-sponsored plans. So Beth, earlier, just a second ago, Ross was talking about some innovative plan designs, product designs. So what do you think the role of the agent should be when evaluating these vendors?
I think that's a really good question. And frankly, I think it's something that agencies have to ask themselves, right? Oftentimes, these vendors are coming to you first and saying, hey, help us basically sell this product, right? And they are guaranteeing you that you're going to get a certain amount of PPM for the clients that you sign up for. And there's obviously kind of a business case for you to potentially get into bed with them. And what I always caution is, that's you putting your reputation on the line by going into business with them. I often caution agencies that if you are going to do that, then it would probably benefit you or behoove you to have an attorney review their product for you before you sell it, right? And that's especially if you are going to take it to the clients. In other situations, the client comes to you with said product, right? And I think what is always a good point to point out to your clients is that a vendor, frankly, is trying to sell you something. Sorry to the vendors here, right? And for the last several years, people like us have gotten called into conversations because vendors said that this is totally legal and nothing is wrong with it. And then you get just someone who knows what the law says, and they're like, no, this is not a compliant design. If your client has already put this into place, it is harder to go backwards and take away something that you have now committed to take paid to employees. And so I think as an agency, if your client brings you these type of innovative things, and not all of them are wrong. If you noticed in our last session, he actually talked about some that can be totally compliant, right? Ross talked about some that are probably illegal. But the point is, they're not all bad, right? But the question is, are they actually compliant, one? And then if there are hoops that need to be jumped through to make sure that they remain compliant, what are those and does your client know, okay? And then I also always point out, frankly, these vendors will say, well, we have counsel that bless this, okay? I'm just gonna tell you that's not always true. A lot of times they're lying, okay? But let's say they did. That counsel is not your client's counsel, right? You are not your client's counsel either. And so really your client is only on sure footing or is on the best footing if they go through this with their own counsel as well.
All right, so let's open the floor for some questions. Has anybody thought of anything?
Somebody has to ask one. Somebody.
Yes, ma'am.
So on the MHPAEA audits, a lot of that goes down to the adequacy of the network. But there's such a dearth of mental health people out there, like providers. How can any group be compliant?
So her question basically has to do with mental health parity and the fact that a large piece of NQTLs is whether the network is adequate, okay? I'll just speak to this one. So NQTLs, frankly, were put in by the insurance carriers and TPAs. The employer didn't set up the network. I mean, with some very, very, very extreme exceptions, right? Your vast majority of clients in this room, they just got whatever network the group have in place, and that's what they're dealing with, right? Network adequacy is something where I think that the DOL is trying to address that with the insurance carriers and TPAs, because your clients literally cannot do anything about network adequacy. Now, could some of the larger employers decide to say, well, hey, we see that, you know, we have parts of the country or places in the country where they don't have as many providers. Can we then, you have, let's say, a Carve-Out or a vendor that also is in that area and can kind of get our people some more options? Maybe, but the vast majority of employers don't have that as an option, right? I think the important thing there is just to make sure you have your NQTL comparative analysis, because that's what the DOL and the law requires right now. And that gets you a long way with the random investigator.
And quite frankly, the plan sponsor investigation is an en route to go through the plan to the TPA carrier to address the issues and concerns at the TPA carrier level, right? So if your TPA carrier is limiting the network by reducing the amount of pay that they're paying their providers, or squeezing out whole hospital systems, because we had this. Yeah, we just did this. We fixed it yesterday. But we're squeezing out entire hospital systems because you can't negotiate the rates like you need to in a timely fashion. That is a question as to whether or not there's going to be an adequate network for those claimants and for those P's and D's, those participants and beneficiaries. What the plan sponsor can do at that level is very minimal, right? Beth has already said that. Some of your larger folks, if you see something, say something, you know that there's a problem, you have the pool, right? The financial pool to say, hey, Blues, hey, UAC, this network doesn't look like it's sufficient to us. You need to do something about it. And some of those newer rules that were in question actually kind of speak to that duty for those types of plan sponsors, right? But where you don't have that kind of financial pool, those plans are an inroad to go to the TPA and to the carrier and say, you're not paying enough. You're upsetting the very few people in this space who can do this type of work, and they're pulling out of your network because you're not paying enough. Pay more. Do something. Fix it because it's you. It's not fun. You know, we would rather that they just go directly to the TPA and the carrier, but that would take literally an act of Congress. Like, we really would need a law that said that the DOL could do that, and they don't have that right now. So they're doing the best they can do. I sound sympathetic because I used to be one, but I understand the process, right? And that's why we're here, is to get our clients to understand the process. We know y'all can't do it, but this is the best direction we have so far.
Do you have any other questions? All right, any closing remarks from our panelists?
Ross, do you want to tell them about NABID? Oh, good. They discussed it already. Fantastic.
Yeah. All right. So thank you to our very distinguished panel. Thank you all